Okay, Your Honor. Firstly, I certainly am not declining or refusing to retain counsel. That's not the situation at all. The attorneys with whom I've consulted, and there are numerous, simply are not available. Their caseload is such that they simply couldn't take me on, and it would have required, if I could do it, it would have required a very, very large retainer, which was simply not an option. So if I can go back to the hearing that we had on the lift stay, there are certain things that you made, Your Honor, in your summary at the end that I disagree with respectfully. One is you said, well, it's true that I have provided no evidentiary support for my position with regard to the accounting. This is specifically, of course, because the defendants are the ones holding that accounting. They have not provided an accounting. I cannot prove anything until we have gone through discovery and actually have had a chance to look at those third-party payments. You made the statement that no payments have been made on the obligation. My payments have ceased for a period of time. However, other payments have been made and have continued to be made. Yes.
I'm allowing you to appear telephonically, but you don't talk over the court.
I'm sorry.
All right?
My apologies.
The first problem is you said that there's a difficulty with the accounting. You believe that it is the secured creditor's burden of proof. You believe that there are third-party payments. What does that mean?
That means that Your Honor, I have been told that by people who know this aspect of securitized home mortgages.
Okay, you need to break that down further. What do you mean?
I mean specifically that it is my understanding that payments have been made on my obligation, not by me, but by others, that are significant, that are germane to the amount owing on the loan.
Okay, now again, let's break it down further. Creditors transfer notes, transfer obligations. They do it for a variety of reasons.
Understood.
Nothing to do with your obligation.
Okay.
Okay, do you understand that?
Well, I'm told that it does. It does affect the amount owing on my obligation is affected by, for example, by the credit default swaps.
Hey, you cannot talk over the court.
My apologies.
If I'm interjecting, if I'm asking you questions, I'm trying to basically move forward with the argument and get you on track.
Okay.
You cannot talk over the court. If you keep doing it, I'm going to have to disconnect you. Are you with me on this?
Yes, Your Honor. I apologize. I simply don't know where the boundaries lie there, so my apologies.
So, again, I need to ask you a series of questions. I'm not trying to interrupt you or whatever, but I'm trying to focus your argument. Because we can't keep going on where you make vague allegations. We need to focus it for now. This is it. This is a hearing on a motion to dismiss with prejudice. So, again, let me just focus on where we are. If I understand your concern, because of this securitization process, or perhaps because of other transfers, Bank of New York Mellon may be the holder of the note. But because of a series of transactions, that may have gone from party to party to party. I think part of the process was, quite frankly, when Countrywide was taken over, the FDIC, other government entities may have stepped in and transferred some of these loans. But here's the problem. The fact that a secured creditor transfers the obligation from one bank to another bank, etc., whatever is paid for that obligation has nothing to do with your requirement to repay money that you got. So, if there's something else going on, let me know. But if that is your concern, we've talked about it before, and you're quite simply wrong on it.
Okay.
Is there anything else on this accounting, third parties, anything else going on
Your Honor, that's not really my position. I do understand that these notes are transferred. Now, however, in this particular case, none of these transfers are recorded at the Yavapai County. I don't know what that means. I believe discovery would reveal certain things, but I cannot know that without discovery. So again, I'm trying not to talk over the court. All I can say is that I have an expert witness who's one of the leading authorities in this field. The court may or may not agree with him, but he has very strong opinions. He is a Wall Street insider. He understands what happened, how it happened, why it happened, and is able to be very articulate on the subject. I've submitted a declaration from him, and once discovery is done, he can analyze that in ways that I simply am not capable of, Your Honor.
We have been down this road before in the sense that there is a district court case, I'm sure I've cited it to you before, Cervantes, I'll cite it to you again.
Yeah, I'm very aware of Cervantes, Your Honor.
As you know, it is not required through MERS and the setup of MERS, which has been determined not to be a sham. It is not required that each and every security creditor go in and record their deed of trust. So your statement, gee, none of these are recorded in Yavapai County, etc., your concern with MERS, the concern that we have the deed of trust that's originally recorded and that through the MERS system there have been subsequent transfers under Cervantes does not hold water. And we've talked about that. Is there anything else?
Well, the only specific thing that is on record at the Yavapai County Recorder's Office is a substitution of trustee, where MERS is substituting the trustee from, I'm not certain what the original one was, but to Recon Trust. And my understanding simply is that MERS does not have the authority to do a transfer of that nature, a substitution of that nature. So there are issues that could be, perhaps should be important. But again, all I can do, Your Honor, is to state that I've done everything in my power to present my causes of action in a coherent way. And we're here on a motion to dismiss from the defendants, who Mr. Hirsch said do not include Countrywide, but of course Countrywide is now BAC Home Loans Servicing LP, and in my earlier pleadings that was stated as a formerly known as for FKA. So I'm not specifically naming Countrywide because I believe Countrywide doesn't exist at this point. I do, however, name BAC.
What other arguments do you have?
Your Honor, again, all I can say is my arguments are in my papers, in my pleadings.
Your papers don't make a lot of sense. We've gone over this with you. Now is the time, if you wish to articulate whatever your claims are, whatever basis you think you should get relief. I've discussed this with you any number of times.
Well, Your Honor, that really puts me on the spot, because to do a full oral argument at this point where I feel that my pleadings express it as eloquently as I'm capable of, short of reading to you from those, I don't know how I would respond.
Okay, again, we've been over this before. We've had several hearings. This is the third amended complaint. I have yet another motion to dismiss. I have discussed this with you over and over and over again. This is the time. You've known that this is set for oral argument. You've been here for other oral arguments. And this is the time to present your position, because right now it is not articulated, it is not set forth in a coherent basis before this court.
Your Honor, I'm sorry, but I do not know what to say.
Is there anything else you wish to present to the court?
Not at this time, Your Honor.
A motion to dismiss with prejudice.
No, I have nothing further to present at this time, Your Honor.
All right. Anything else from you, Mr. Hirsch?
Just one brief point of clarification. Mr. Bailey mentioned that BAC Home Loan Servicing LP is formerly known as Countrywide Home Loans. That's not correct. BAC Home Loan Servicing it took over the servicing aspect of Countrywide, which is different from the entity that entered into the loan and made the alleged.
Right.
Just want to make sure the record's clear.
Okay, understood.
Thank you, Your Honor.
Thanks. You'll get the decision of the court shortly. That's it for today. I'll go on to the next matter.
Thank you, Your Honor.